What's up, everybody? This is John Deaton. Welcome to Crypto Law TV and our first live stream. With that said, I'm live from New York. It's not Saturday night, it's Tuesday, and we've got a lot of things to talk about. If you have a question, go to the chat feature and comments section of YouTube, and we'll get to as many questions as we can. First things, I thought I was going to be talking about a couple things tonight. I thought I'd be talking about the hearing today, and I thought I'd be talking about the SEC's opposition to our amicus brief that we want to file related to Patrick Doody. But as of just a few seconds ago, the SEC has not filed that opposition. They have until midnight. Also, 1 week from tonight, Crypto Law TV is doing a special. It is the 4th year anniversary of the June 14th, 2018 speech by Bill Hinman. And it's not just going to be me. We're going to have a few guests. Eleanor Terrett's going to show up. Jeremy Hogan's going to show up. And we're going to have a couple other guests to be announced later. Also, J.W. Verrett's going to show up. We're going to talk policy. We're going to talk Cynthia Loomis spill, all those things. So tune in for that. Right now, let's talk about the hearing. The hearing, I showed up live because we just hit 67,775 XRP holders from the United States and around the world. And that deserves recognition. 67,775 people. So I just wanted to show up to let that presence be known. Let the SEC see us there. Ripple lawyers see us there. The court see us there. And so that's the reason I went. Now, a couple observations about today's hearing. First thing I want to tell you is that it became apparent to me right away why we were having a hearing. And at first I questioned it. I said, why is she doing this, right? She's dealt with this issue for over a year, and then it hit me. And it hit me as soon as she started putting comments on the record. We had a hearing today so that she could use statements by the SEC's attorney in today's hearing in her written opinion. I have no doubt about it. Mark my word, it will show up in her written opinion. A couple of those comments, okay? Help me understand what advice Hinman received. What was he seeking advice for? Do you stand by the position last year that the speech was his personal opinion, which never got answered, by the way? The SEC has distanced itself from that speech as his personal opinion. She said that 3 times, maybe 2, could be 3 times. The SEC has said his opinion can't be imputed on the SEC. She slapped the SEC attorney down saying, did you just say in his capacity as director? And then brought out the fact, isn't that inconsistent? And so she was getting statements because she was asking very poignant questions. What advice was he seeking? The other thing I want you to know is that we all learned something today, a rule of oral arguments. And that is the attorney who talks the most, the attorney who repeats the most, is the attorney with the losing hand. If you counted the clock today, I guarantee you the SEC attorney had 3 times, maybe 4 times the amount of time that Attorney Solomon had. And sometimes less is more. And you saw what a difficult position that attorney was in just by the way she handled the questioning. And the other thing I'd bring out is, where are some of the other attorneys, right? It seems like we're getting a new attorney each hearing. There's somebody different. Now, they're either pushing this case off to other people at a lower level, or possibly they're giving young attorneys an opportunity to cut their teeth, is sort of the way we phrase it, to do some oral arguments for the first time. But those are my general observations. We're going to try to do this in like a half hour. I want to get to your questions, and let's start there. All right, we got a question here. Does the SEC settle if they lose the next ruling? Well, my position hasn't changed. which is, and I know DAI has said this and other people have said this, which is those emails, those comments are never going to see the light of day outside of the SEC's office. And so my position remains the same. When the SEC is forced to turn over those documents, that's when a settlement could happen. If the judge does something which I don't believe she'll do, and she decides to not make them produce the documents, then this case is going to summary judgment. But we just need that to happen. The other reason, Judge Netburn knows that this case is getting appealed, at least to her decision on this Hinman email stuff, that's getting appealed to at least Judge Torres. And so another reason of having the attorneys come on the record and get them committed to their statements on the record is to make it bulletproof. All right, the question is, how much BS can the judge take? Listen, Judge Netburn proved to me today two things. She proved to me what I've always said. She's a very smart judge. And she proved to me that if her temperament is what's required, then I shouldn't be a judge, because I don't have that kind of patience. You know, when the SEC attorney again at the end said, "Judge, can I be heard again?" At a minimum, I would have said, as long as you don't say one thing more repetitive, right? I would have at least been more forceful in those things. But Judge Netburn is super professional, super accommodating to attorneys. And maybe that's the way a judge should be. But I agree. I lack the patience and maybe the temperament, because I would have been a little more forceful. The other thing is, this securities litigation is something different than what I'm used to, right? Even the way Matthew Solomon, you know, he's so professional and colloquial, and where he says, you know, Judge, we don't relish in pointing out these inconsistencies. I got to admit, I kind of would relish pointing out those inconsistencies. I'd be like, Judge, tomorrow there'll be another argument. You know, if we argue something else, they'll go back to their first decision that it's his personal opinion. And but anyways, let's go to the next one. I don't want to go on a tangent. Did today's hearing bring the case closer to settling? I think as long as the ruling comes out, what's going to determine that, everybody, is whether or not Judge Torres would allow the SEC to certify an appeal, which I don't think. I think that the opinion will be bulletproof. Listen, I'm someone who's went on record to say that there's something in those emails that the SEC desperately doesn't want Ripple to know. Again, even if it's just a comment about, well, what about XRP? You know, isn't XRP arguably more decentralized than Ether or whatever? There's got to be some kind of reference that they believe is going to cost them to lose. And if there is something in those emails that costs them to lose, then why would they risk losing when they could go to Ripple and get a significant sum of money for a settlement, and then Gary Gensler could make us all upset to our stomach by bragging how he got one of the largest settlements in SEC history, blah, blah, blah. Can Torres write up in her order no appeal to the Second Circuit? I have to be honest, I'm not an expert on appeals. I believe on an issue, a discovery issue of this, she has to certify that it would go up and allow it to go up. I'll get back to you. I'll tweet something out. Maybe I'll call my friend Jimmy Filan, who will probably know that answer off the top of his head. But I'm not going to bullshit you if I don't know. Why did they bring in the third string lawyer? Okay, listen, to be fair to that attorney, she had a losing hand, right? She was thrown in there. She hasn't argued anything that I'm aware of in the past, and she was thrown in there. Now, one thing that I thought of is she doesn't have much experience. If you compare her experience level to Matthew Solomon's, you're going to see night and day. Now, experience is the greatest teacher in life, no matter what you do. So it doesn't mean that Matthew Solomon is that great, better of an attorney. He just has a hell of a lot more experience than her, right? So one thing that I thought of was, all right, we're going to lose this argument. So you go in there and cut your teeth and get some experience under you, and how you respond to a judge. It could have been her first argument, could have been her 100th argument. I don't know, but that's one thing that I thought of. I have noticed that Jorge Tenrero has not been actively involved. Maybe he got promoted and he's doing other things, or maybe he hands it off to someone for the loss. What did this mean for XRP holders, the Amicus status? Well, me being there means nothing other than a symbolic gesture that 67,715 people want to be heard. That's all that means. We're going to get the decision, not the decision, but the opposition from the SEC at some point tonight. And I do want to just comment on it. And I sent a tweet out. You can look it up, where I made a prediction that the SEC is going to, say, Judge, if you allow Deaton to write a brief, we need more time. They don't need more time. I said that our brief could be 2 weeks before the final brief of the parties. So they'd have 2 weeks to look at anything I say and be able to reply. I said that they may attack me and claim that I'm trying to violate her order I brought up affidavits. I didn't give the court any affidavits. That would all be nonsense. I gave it to the parties. But the SEC knows that XRP holders fear one thing, right? We fear, if anything, it's delay, delay, delay. And so I will not be surprised if they try to use that to instill fear. But trust me, I won't let it happen. It's just a scare tactic. In your best guess, how will it take for her to rule on the Hinman emails? I would predict that she gets an answer to us in writing within 2 weeks, hopefully by the end of next week. I predict that it will be that the Hinman emails are to be turned over. Listen, the SEC had one argument, valid argument. Bill Hinman, as the director of corporation finance, they each get a special attorney, just like Hester Peirce has special counsel to Commissioner Hester Peirce. They could argue that guy's communications with Bill Hinman could be privileged. But aside from that, going in there today and arguing every single document, every single draft, every single comment by all the people involved in the email are all privileged by attorney-client privilege. It's nonsense. And so when you go in making just a silly argument on its face, you're going to get what's called smacked down, like what happened today. Why would Ripple settle? They've come this far. They would settle because I've said, and I know a lot of you disagree with me, and that's okay, but I believe that you can never underestimate the impact that the United States is as far as being able to have liquidity and certainty and move on. And I think that if Ripple could agree to, okay, in 2013, when we gave someone an options contract on some XRP as an investor, we'll agree that that was a security. And, here's 20 million XRP. Let's get a decision that today and ongoing and future sales of XRP are not a security, and they get that certainty and there's no appeal thereafter. Understand, even if there's a ruling in Ripple's favor, the SEC can say, well, the judge shouldn't have turned over the Hinman emails. The judge shouldn't have done this. The judge shouldn't have let Deaton and the amici in the case. We need to overturn the ruling and appeal it to the higher court. And so Ripple would settle just for complete certainty, complete freedom that this case is over with and they can get back to business. They're one of the few companies in crypto that's hiring, whereas the other companies are starting to lay people off or at least freeze their hiring. So that's the reason they would settle. How do I feel about the integrity of the judges? A lot of you have disagreed with me. I believe that the judges have been outstanding. Delay is something that is going to happen. I believe that Judge Netburn is more patient than I am. I believe that she's more methodical than I am. What that means is she's a better judge than I would be. Okay, that's what that means. But I think that we got lucky, okay, that we got two judges who are conscientious. They may be slow to our liking, but they've taken this case and they've been good rulings. There are some judges out there, what we call our government hacks. And that means they side for the government. They side for the government every time, all the time. Trust me, that happens. They rubber stamp what the federal government wants because they have future aspirations, right? And so I don't see that with these judges. So I think they're outstanding. What was the atmosphere like in the courtroom? It was very low key. There weren't a lot of people. There was one XRP holder that I knew of that I talked to, and Stuart Alderati was in the courtroom with some other people that I'm assuming are part of Ripple's in-house legal team, or maybe they were associates. And you had Marty, who is Chris Larson's lawyer. You had Lisa Zornberg, who I think is a firecracker. A lot of you don't know her, but I think she's a firecracker, and I mean that in a very positive, favorable. We all know Matt Solomon as well. It was very low-key. Everyone kept to themselves. You know, I really didn't talk to anyone, to be honest with you. I wasn't there, you know, to talk to the SEC or talk to Ripple. I was just there to remind people that there's 67,750 people that are paying attention. I was expecting more fire from Solomon today, but he seemed tame. What's your opinion? You know, it's hard to argue against Matt Solomon, and if I do, Jeremy Hogan is going to like call me and like give me a tongue lashing, if you will, because that's his boy. Very eloquent guy. I agree that I think he knew he had the winning hand. You know, again, you got to understand, everybody, this kind of litigation is very different than what I'm used to. I'm used to, you know, my clients are dying and I go in there and I'm kind of like, you know, a lot more forceful in times. You know, for example, when Matthew Solomon said what I think I already said, which is, you know, Your Honor, we don't like, you know, pointing out these inconsistencies, or we don't relish it. Forget that, man. You know, that's sort of my thought. They're coming in here every single day with a different argument, right? Every single day they change their mind, they flip-flop, they fight the people that they are supposed to be protecting. We're going to get an opposition tonight of the people, they're opposing the people who they allegedly filed the lawsuit for because they don't want us to be heard, right? They hired a guy who's going to say what we think. They hired a guy who's going to say why we bought XRP and that we should just sit down and shut up and not be heard. So, you know, I have a lot more fire in my belly, but to be fair to Matthew Solomon, he's not getting emailed by 67,000 people. He's not reading emails about someone who got liquidated at the lawsuit and lost their father's life savings. He's not getting emails about someone who lost their college education for their children. You know, maybe they shouldn't have been on margin, but they shouldn't have lost it because the SEC filed a bullshit sham lawsuit. All right. And so he's not getting those kind of emails, but he's an outstanding lawyer and he's a lot more eloquent than I am. And so I could never criticize your Monday morning quarterback. Is the SEC's goal to take this to trial? The answer is yes, unless they have a reason not to. And that reason could be the emails, or somebody comes to Gary Gensler and says, we're going to lose bad, and there's going to be a legal precedent that puts us out of business. All right? It could be that where he comes to the table. They could also be eyeing the bill and what this Cynthia Loomis bill, you know, what potential does it have? Is it going to give everything to the commodities, the CFTC? And so if they think they're going to lose jurisdiction to the CFTC, why not roll the dice on the lawsuit? So I think our best bet for a settlement is from today's hearing, and that's why we're doing the live stream, because the only way this case settles is if they have to turn over those emails, you know, before the end of this year. Can the SEC recant anything the SEC lawyer said today, asking just because she seemed inexperienced? I get that question, but the judge, again, had this hearing today because, she came out the bat and she said she wanted to get statements on the record. She said, I want you to tell me what legal advice he was seeking. And when the lawyer started to give an answer, some of you may have picked up on it. As soon as the lawyer said, well, he wanted to make sure that he wasn't going to say something inconsistent with SEC guidance or policy, the judge locked in on that. And she said, and tried to lock the attorney in. So what you're saying to me is that he was seeking guidance, so he's not inconsistent. That's not seeking legal advice, right? There's a big difference. And that's why she kept focusing on what was the purpose of the legal advice. What was he seeking advice for, right? Because he can't seek advice for his legal opinion. And so, no, I don't think they're going to have a shot in hell in trying to recant that. Were there XRP holders at court? Just one that I spoke to as far as XRP holders. Let's see, how long can this case be delayed for? I think the case is set. Don't let the SEC's threat, if it comes out tonight where they're like, hey, Deaton's brief, we need more time. I said I'm not going to let that happen, all right? And there's a way to not let that happen. But sure, they're going to threaten it. I think the judge isn't going to move this case anymore for any reason. Discovery's closed. We're now in the briefing stage. There will be a brief, whether I'm involved or not. There's going to be a challenge to Patrick Duty by Ripple, and then there's going to be summary judgments. And the summary judgments are all briefing due by the end of December. Now, what that means is November. So what that means is it likely that she's going to, with Thanksgiving and Christmas, give a written decision on a case that she just got the briefs a few weeks before? No. It's never going to happen. I'll just be honest. You're not going to get a decision from Judge Torres by the end of this year. Might get a settlement, but you won't get a decision. The question is, will the decision come in January, February, or March? Right? And my guess would be somewhere in March, if it goes to a decision. I'm sorry. I know that's bad news for a lot of people, but that's the honest answer. Will the Loomis bill have any effect on this case? I have to be candid. I haven't read through the bill because I've been tied up doing other things. I was a little worried about the bill. From what I hear, it's not as bad. I saw a few comments. It really comes down to the devil in the details. If they use language that fits a functioning network, a functional network that's been pre-existing, and that's a commodity, then it could actually usurp this case, right? If Congress comes down and changes the law, creates the law, gives specific guidelines, then the question is, do they name tokens or do they just give more specific definitions, right? Are they going to eventually do something like the UK does and say that we have security tokens and then go through all the, say the top 100 and labels which ones are security tokens, which ones are utility tokens, which ones are exchange tokens? I doubt that Congress does that. So they'll use some kind of terminology that XRP could fit, and it could completely usurp this case. Now, that requires a Senate bill getting through and then it going to the House and it getting through the House and then the president signing it. That's something that's not going to happen overnight. So I believe, if I have to pick, I believe that we'll see a ruling before we see something from the Senate and the House and signed by the president. But maybe I'm wrong. Could this case be used as the new Howey test? Well, unfortunately, The only way that happens is if it goes to the Supreme Court of the United States, or at least goes to the Second Circuit. And we certainly don't want a decision that XRP is a security, and we have to get it that way, because that would require appeals, and we would be in this position of purgatory, to steal Brad Garlinghouse's word, for years, 5, 6, 7 years. And so a Ripple test is only really likely if it comes like in the congressional way, right? In a bill where you use this case or you use these facts and you formulate legislation. But remember, the Howey is a United States Supreme Court decision from 1946. And we'd get a judgment here next year, then it would get to the Second Circuit. That would take 18 months. And then the Supreme Court would take a couple years at a minimum. So you're talking 5 years from now. So we don't want a Ripple test. And I do want to comment real quick on the fair notice defense, because I think a lot of people confuse the fair notice defense. We don't want the court to decide fair notice. We want to win on a strict Howey analysis, because believe it or not, and the reason why I got involved, and the reason why I went to court today, and the reason I'm doing this, the fair notice defense, if the judge could say you didn't have fair notice, so you don't have to pay the 1.3 billion, but XRP is a security. And then Ripple has to then, only sell to accredited investors in the United States. So the fair notice defense is about this period of time for the last 8 years. Was Ripple given fair notice that XRP is a security? Now, do I think the judge is going to do that? No, but that is a possibility, worst case scenario, where Ripple's okay, right? They sell to accredited investors. They don't have to pay the $1.3 billion. Hurts their business, but they survive and they do well. XRP holders are left stranded. And that's why we have to keep fighting the way we do. Do you think SEC resources are being redirected to the Binance case? And if the Binance case is for their IPO, how is ETH not on the chopping block? Listen, many of you know in January, I said that the SEC is going to go after the exchanges. One of them, two of them, three of them. Listen, when they told Brian Armstrong that they were going to sue the Coinbase for the Lend product, right? I tweeted, you know what you should do, Brian? You should relist XRP and immediately file for an amicus brief to be heard in this case. But I'm afraid that these other crypto projects, they're all kind of scared. They don't want to be involved with the SEC, and they're hoping they don't come after them. This case will set the precedent. If XRP is deemed a security, then they're all securities except for Bitcoin. ETH's a security. Now, if they change it in the bill and they say that ETH's a commodity, that's something different. That's congressional. I'm just talking about this case. If XRP, today's XRP is a security, there is no possible way that ETH isn't. And if the ETH people think that Gary Gensler isn't going to go after them, if there's political pressure to do it, then they're silly. All right. I think that's any last questions? I think that was last of it. Let me check before we get offline, even though we don't have time to go over it. Nope. The SEC has not filed their opposition yet to our amicus brief request. Remember, 2 weeks from tonight, it's not just going to be me. You get to hear people other than me. Jeremy Hogan, Eleanor Terrett, J.W. Verrett, and others guests are going to discuss the 4th anniversary of the Hinman speech. We're going to get into the ethics issue. We're going to get into what the speech did for policy and regulation and how it led to even the Cynthia Loomis bill. So tune in next week. Until then, I'll see you next time.